you've been able to join us today. Again, I am Vicki Levengood, the Communications Director for the Michigan Department of Civil Rights. We're here with you this morning to announce that the Department of Civil Rights has filed a formal charge of discrimination against the Studio 8 Hair Lab LLC in Traverse City. I'd like to introduce now the people you'll be hearing from shortly. The first speaker will be MDCR's Executive Director, John E. Johnson Jr., who will give you an overview of the charge and its importance. Next, MDCR's Director of Enforcement, Marcelina Trevino, will go over some of the specifics of the process and what happens next. On deck, we also have, and they'll be joining by camera during the Q&A, our Director of Legal Affairs, Bryant Oskowitz. Sorry about that, Bryant. I knew I would do that. And MDCR staff attorney, Alana Buford Cameraman, who reviewed the work of our terrific investigators who were responsible for looking into the Studio A issue and the complaints that we'd received. And Alana is the attorney who drafted the charge. They are here to help us with your more targeted questions into the details of the investigation and the charge we filed today. After Director Johnson and Director Trevino have spoken, we'll open it up to your questions. I'd like at this point to turn it over then to Director Johnson, who will begin, and then Director, when you're finished, if you'll throw it back to me, we'll have Marcelina make her remarks. Director? You're muted, Director.
There,
perfect.
Yeah, I apologize. Good morning, everyone, and thank you, Vicki. As she mentioned, I'm Director of the Department here of Civil Rights. And I want to thank you all for joining us today for this press conference. This morning, our department filed a charge of discrimination against the Studio 8 Hair Lab located in Traverse City. As you will see when you read the actual charge, this is not a complicated case. It is not a case that relies on complex legal concepts or requires expansive or convoluted arguments to explain. But none of that is to say it is not an important case. It is. I also feel it is important to say what this case is not about. It is not about free speech. It has absolutely nothing to do with our First Amendment rights. That is a red herring designed to grab and divert our attention away from the real violations of law and Christine Geiger's responsibilities under law as the owner of a business offering services to the public in the state of Michigan. Understanding the real violations we assert the respondent committed and the final determination in this case will be important to business owners throughout this state. Every complaint we investigate takes a neutral and impartial perspective. We are not advocates for the claimant or the respondent, but once we establish what we believe is the truth of a specific complaint, we act on it. In this case, the truth is based on a thorough investigation that Studio 8 and its owner, Christine Geiger, openly and repeatedly violated the Elliott Larson Civil Rights Act. We assert that the owners of Studio 8 flagrantly violated the provisions of ELCRA that deal with public accommodations. Now, that term, public accommodation, can be confusing. The clear language of the statute defines a public accommodation, and I abbreviate in the interest of time as, quote, a business whose goods or services are made available to the public, end quote. Our press release will include the full language, but it is easily apparent that Studio 8 is a public accommodation as described in the law. Equally clear are the ways in which Studio 8 violated the law by denying their services to specific individuals based on sex. In this case, the respondent made sure that people in her community and beyond knew her position by publishing comments on social media, spelling out the people she would refuse to serve and why. If a person did not fit her definition of sex, they were not welcome to take part in the same services offered to every other member of the public. If your sexual orientation, gender identity, or expression was not on her list of what was acceptable, you could seek out the services, in her words, of a dog groomer. It is important to say that the owner of Studio 8 need not literally to have shoved someone out of her doors to be found in violation of ELCRA. The law makes it exceptionally clear that it is a violation of civil rights law, and again, I abbreviate in the interest of time, to, quote, print, post, or publish a statement or notice which indicates that the full and equal enjoyment of the goods, services, and facilities of a public accommodation will be refused an individual because of religion, race, color, national origin, age, sex, or marital status, or that individual's patronage of a place of public accommodation is objectionable, unwelcome, or undesirable because of religion, race, color, national origin, age, sex, or marital status. I will now turn things back over to Vicki, who will introduce Attorney Marcelina Trevino, the Director of our Enforcement Division, who can describe our complaint investigation process and what happens next now that we have filed a formal charge of discrimination. Vicki?
Thank you, Director. I now turn it over to Marcelina Trevino, the Director of our Enforcement Division. Marcelina?
Thank you, Vicki. Thank you, Director. Yes, at this time, as noted by the Director, we have issued a charge this morning. I want to take you through the investigative process to understand how we came to where we are today. The department received several complaints of discrimination, of which currently 3 were taken and made into certified complaints, stating that we had jurisdiction to investigate the allegations of unlawful discrimination, unlawful advertising by a public accommodation business in which individuals felt that they were impacted by this advertisement. Next, we conducted an investigation on these complaints and found that there was sufficient evidence to move forward for a charge. At that point, the complaints and investigations were turned over to our legal department, to our staff attorney, Alana Buford-Kammerman, to begin conciliation, meaning that she attempted to set up a meeting with the respondent to address the issues in the complaint and to go over the sufficient evidence that we found. To our dismay, the respondent refused to participate in conciliation, and therefore our staff attorney, Alana Buford-Kammerman, drafted a charge, which was filed this morning with the Michigan Office of, Administrative Hearings and Rules. At this point now, we will move forward and a hearing will be scheduled for an administrative law judge to hear the merits of this complaint. After that, once a hearing is conducted and/or hearings are necessary, the administrative law judge will issue a recommendation that will go to our Michigan Civil Rights Commission for review. At that time, the commission will review the recommendation and decide to adopt the recommendation as was written by the administrative law judge, or may adopt their own opinion and finding on the matter. In addition to that, they may determine that additional hearings are necessary in moving forward with a final order and determination. As with all of our charges and complaints, if either party is unsatisfied with the determination from the commission, it is appealable up to the circuit court of the state, having jurisdiction over the matter. At this time, I'm going to turn it back over to Vicki. Thank you.
Thank you so much, Marcelina. We now welcome questions from the reporters on the call. How we'll handle this, please put your name and the media outlet for which you work into the chat, and Harold Core on our team will call on you, unmute your line, and you'll be able to ask the question. So Harold, at this time, are you ready to begin the questions? Oh, and before we go any further, I wanted to, you notice we have a couple of new folks appearing on your screen. We have Bryant Oskowitz, who is our Director of Legal Affairs, and the attorney who drafted the charge, Alana Buford Cameraman. They will be available if we get into issues that only they would understand or know. So please, again, Harold, do we have any questions in the chat at this point?
Morning, this is Harold Kaur. We do in fact have several questions in the chat. First question, Jordan Hermani from MLive. You're able to speak.
Hi, thanks for taking my question. It's a bit of a two-parter, one-part clarification. I understand that there are 3 claimants in this charge. So this is one charge of discrimination, or is this 3 separate charges of discrimination? And then my actual question is, how was it determined that these specific individuals were able to continue on in the complaint process? I understand that about 21 different complaints were filed. There's been about 8 in the process of review, another 2 for jurisdiction issues. But how did we land on these 3 individuals?
If I may, I will address that issue. So these 3 complaints initially, which are on the initial charge that was filed this morning, are all included. So it is one charge that includes the 3 different investigative complaints in that. As far as the second part of your question, as being able to file a complaint in this scenario, we have individuals who are of a protected basis under sex, who viewed and were impacted by an advertisement that was posted by the public accommodation, which is the respondent, the Studio 8 Hair Lab. In that, we have, as well as being timely within 180 days. Within that, we determined that we have jurisdiction to move forward with the investigations on this matter, and now are at a place of charge.
So these individuals didn't specifically pay. I understand that Director Johnson said that you don't need to have somebody literally kicking you out the door to violate civil rights law, but these 3 specifically, I've looked at the complaint. How exactly were they impacted outside of, I understand it's 2 non-binary individuals and a cisgender woman who filed these complaints?
Just by posting, having an advertisement posting would allow jurisdiction for someone to file, because it impacts them on being able to receive services from a public accommodation. So it's really centered on the advertisement and the impact that that may have on individuals.
Thank you.
Okay, next question, Lily Guiney from Michigan Advance. You have the floor.
Thanks, guys. And thanks for taking the time. So we've seen that Ms. Geiger has filed her own lawsuit against the 3 complainants in this case. So I guess this might be sort of a nebulous question. Do the people who file these complaints have any sort of legal protection? Is there any sort of basis to like the MDCR's policy? Like, do you guys have some sort of way of protecting people who file complaints from legal retribution? Is that a concern at all going forward? Just sort of, is there really a ground to sue someone for filing one of these complaints?
This is Marcelina speaking again. At this time, we cannot address any of the issues that are happening in the lawsuit that we are not a party to. However, I will state that under the Elliott Larson Civil Rights Act, there are protections against retaliation for participating in a protected activity, such as filing an unlawful discrimination complaint with our department.
Thank you.
Next question, Beth LeBlanc from the Detroit News.
Hey, thank you for taking some of these questions. I guess I just wanted to clarify, I know Mr. Johnson touched on this, but in your investigation, did you find any proof that this Studio 8 hair salon turned away anyone, like physically, or is it just the advertisement? And if it is just the advertisement, how many other cases have you handled in the past where you charged someone based on an advertisement?
Thank you. I'll take that question. Again, this is a case that is based on the advertisement publishing of an unlawful discrimination comment of a refusal to issue services. I cannot note in the past of charges, and there have not been recent charges. However, in the past, the department has had investigations dealing with unlawful discriminative advertisements in the past.
Okay, just to follow up on that, 'cause I don't know that you answered it directly. Have you found any proof that this hair salon turned people away directly?
We have not received a complaint nor investigated whether the hair salon has specifically denied services, which is why that is not part of the charge in this matter.
Okay. Thank you. Next comment, Paul Egan, Detroit Free Press.
Good morning and thank you. It sounds like the respondent declined to participate in the investigation or the conciliation, and I haven't seen Ms. Geiger's lawsuit, but what I'm wondering is, did the investigation turn up any evidence either through social media posts or any other source that she was claiming any kind of religious belief? And can one of the attorneys maybe comment on whether, the fairly recent U.S. Supreme Court ruling in terms of, religious convictions could at all complicate this case?
At this time, I will turn it over, if that's okay, to either Bryant or Alana for that answer.
This is Alana Buford, cameraman speaking.
Alana, this is Vicky. Could you speak up a bit? I think folks may be having trouble hearing you. Maybe your mic is not close enough. Thank you.
Thank you, Vicky. Is this better?
Yes.
Wonderful. Thank you for that heads up. Regarding the investigation, when you look to the charge, you will note that all of the facts in that case, rather what you won't see is any reference to Studio 8's any type of religious beliefs, if there's what they are or sincerely held, are not included in that, because as previously stated, this is a case about a discriminatory advertisement. This isn't a First Amendment case. This is about, did Studio 8 publish an advertisement indicating it would participate in unlawful discrimination? As to the second point, as to whether the most recent Supreme Court case from this summer, kind of colloquially known as 303, will impact this case. If that's raised during the proceedings, that will be addressed in MDCR's briefings at that time.
Thank you.
Next question, Jordan Traverse City Record Eagle. Mike is yours.
Hello, and thank you. I just wanted to ask what kind of punitive measures Studio 8 might face as a result of this.
I'll turn this question over to Staff Attorney Buford Cameraman.
This is Alana speaking. As noted in the charge, specifically, there's a request for relief that's outlined that notes what can be requested within the authority of ELCRA. So once those facts are presented before the the administrative law judge, and the commission has the ability to review that recommendation, then that will be what's decided at that point, but based on the facts that are presented during the hearing.
And I just had one more to kind of follow up on the last question there. In any of the posts that you reviewed, did Ms. Geiger or anybody posting on the salon's behalf ever invoke religion or mention any religious beliefs whatsoever?
Again, this is Alana speaking. As stated before, what you'll note in the charge is there's no mention of any type of religion. As stated before, this is not a First Amendment case. This is about the unlawful discriminatory advertisement that was posted. So if that's raised during the proceedings, we'll address that issue for the ALJ in our legal briefs. But at this time, it's not an issue.
And I will also add to that, that this is not about the individual. This is about the Studio 8 Hair Lab, and working through the advertisement through its agent and or owner. So this is about the business, not about the individual.
This is Vicky speaking. I just wanted to add that for our panelists to be aware that the reporters on the call have not yet received the charge. They will receive it right after the news conference. We'll be sending it out with the press release. So if there's a question related directly to what's in the charge, it may be helpful to expand a bit on that because the reporters have not had a chance to read it yet. I thought that might be helpful.
Next question is from Joey Capoletti, Associated Press. You have the microphone.
Hi, thanks for taking questions. The Michigan legislature earlier this year passed, amended the ELCRA law to prohibit discrimination based on sexual orientation and gender identity. But that was not given immediate effect and won't go into effect until sometime in February 2024. Does that complicate this case at all?
This is Marcelina speaking. No, it does not. We have been taking complaints and have jurisdiction under sex for both sexual orientation as well as gender identity or expression under case law, both under the Court of Claims and the Michigan Supreme Court.
Okay, next question. Oh, I'm sorry.
I was just going to say, ask Joey if that handled his question, but we can move forward.
Yes, it did. Thank you.
Great. Thanks, Joey.
Okay, next question is from Lisa Church with Mears. She says she has too much background noise, so she's asking the question in the chat. If Studio 8 is found responsible, what, if anything, is the penalty or punishment?
I'm going to pass this back to Staff Attorney Buford Kammerman, and she can address those issues more specifically from the previous question and answer.
Hello again, this is Alana speaking. Regarding potential outcomes of the hearing, again, one that's going to be determined based on the proceedings, what evidence is presented before the administrative law judge, as well as what recommendation is adopted by the commission. At that point, once you take a look at the charge, and as provided authority under ELCRA, several things have been requested for relief, and that could be the potential outcome in this instance. So I'll direct you to the charge and reviewing that once it's released later today.
This is Vicky. Alana, would you be able to just briefly explain what those options are that are in the charge for the folks who have not had an opportunity yet to read it?
I certainly can. In the charge, MDCR has requested the following relief. First, the respondent to pay monetary compensation to the claimants for any emotional distress or mental anguish which they sustained as a result of the unlawful advertisement. The commission may also deem within its authority just and proper the ability to request payment of reasonable attorney's fees, the extension of all of the full and equal enjoyments of the goods and services offered by Studio 8, requiring Studio 8 to post notices in a conspicuous place with civil rights laws or other relevant information, reporting to the commission its compliance with the civil rights laws, in particular here, the Elliott-Larsen Civil Rights Act. Additionally, the commission may certify to the relevant licensing authorities within the state of Michigan respondents' violation of ELCRA as being grounds for suspension or revocation of respondents' license or licenses.
Thank you so much, Alana. I think that was helpful.
Of course, my pleasure.
Next question is from Alyssa McMurdy with Gongwer News Service. Alyssa, you have the mic.
Hi, I was curious, what's the timeline on this? Do you know when a hearing could be scheduled? And, just how quickly a case of this matter could be turned around?
This is Marceline. I could take that. At this time, since the charge was filed this morning, it really is in the hands of the Michigan Office of Administrative Hearings and Rules Office to schedule the initial meetings and hearings for that. And so there is really no timeline that we can give. It's really going to depend on the answer from the respondent, as well as any other legal questions that need to be answered before moving forward to a hearing and through a hearing.
Thank you. This might also be a question, possibly more so for the judge to decide. But I was just kind of curious, how solid do you think this case is? I know earlier you said you don't have any evidence of these owners turning away people who are non-binary. But one of the relief, I guess, requests would be for them to have monetary payment. How solid would that be if there's no evidence of them physically being turned away?
I'm
Again?
wondering if that, excuse me, I was just wondering if the director might want to take that one, because I think you addressed that a bit in your comments, but Marcelina, please weigh in as well.
Thank you, Director. Again, this issue and unlawful discrimination is, we find, very strong and sufficient, or else we wouldn't have moved forward for a charge. Again, I want to be clear on this, that although the Elliott-Larsen Civil Rights Act prohibits the denial of service in section 302, A for the denial of service, but it goes on to section B of that same section to state that it is unlawful to print, circulate, post, mail, or publish a statement or advertisement. So again, I want to be clear that we are very specific as to the violation here has been the unlawful advertisement and not the denial of services. Okay, so then I should follow up. Therefore, I'm not sure how the administrative law judge will what they'll recommend and or what the Michigan Civil Rights Commission will order.
Got it. Thank you so much.
Okay, it looks like Beth LeBlanc has another question. So Beth, you have the microphone.
Hey, thank you for this. I know you mentioned earlier both that I guess religious freedoms were not being brought up as a defense, and Director Johnson, I know you said earlier that this isn't a free speech issue. Can you walk me through how this isn't a free speech issue? Like, which line, I guess, was crossed that takes that protection away at this point, or if you're able to just kind of touch on that a little bit more.
This is Vicky. I'm thinking that Bryant may have a good response to that. Bryant?
Of course, thank you, Vicky. As been stated before, we're not going to get into the legal issues that may or may not be raised by the respondent. We'll litigate those in front of the administrative law judge. But in general, I will just say that free speech is not absolute. A classic example from law school is, you can't yell fire in a crowded theater, that type of thing. And we were very specific in this charge. This is not a free speech case. This is a discriminatory advertisement case. Alana was careful about that. She did the research too, so she is well versed in the free speech issues that may arise in this case, but we don't think they apply in this case. But as I said, we will litigate those issues in front of the administrative law judge as they are raised.
Thank you, Brian.
Thank you.
Does anyone else have anything to add to that?
Okay, there are no further questions in the chat. Thank you.
Thank you, everyone. We can give it another minute or so if anybody thinks of something. We'd be happy to stick around for a few minutes if you have any additional questions. And I see Joey just put into the chat, yes, the release will be going out. I have to make a couple of tweaks to it due to the great advice of this wonderful legal team. So I will be sending it out within the next 15 minutes or so, and it will have a link to the L.A. Larson Civil Rights Act and to the charge in this case. If there's nothing else, we will end the session for today. Oh, we have Jordan Travis has said he has one more question. Harold, if you can unmute him.
Jordan, you have the microphone.
Hi, thank you. I just wanted to ask how typically, like how many times a year or so, does the Civil Rights Commission investigate this kind of a complaint about discriminatory advertising?
It really depends on the complaints that come in and people who want to move forward with a certified complaint in these matters. I will say that a lot of times businesses will work and cooperate with the department to fix the unlawful discrimination and work through that. So I don't have a number specifically on how many.
Was the first this year?
That we have issued a charge in this matter, yes.
Or any matter like it?
We would have to go back. There have been housing ads, but I can't specifically say this year. We'd have to go back and look at the investigations that we have and complaints.
Okay. Thank you.
I think Jordan might be getting at the whether or not we have taken other complaints of this sort in this year to charge, which we have not, is my understanding. However, we could have, and please correct me if I'm wrong, folks, we could have resolved complaints based on that arose out of a discriminatory advertisement, but they were settled through conciliation. Is that accurate, Marcelina?
That is true. They could have been settled even before conciliation with the investigator and or at conciliation.
Thank you very much. Do we have any other questions?
There are no further questions in the chat.
Terrific. Thank you all for the terrific questions you asked, for your patience with us this morning as we got started. And please know that you can reach out to me at levengoodv@michigan.gov. That's LEVENGOODV @michigan.gov. And I'll be happy to help if you think of some additional questions you want to ask. And note that we will be sending all of you, as soon as possible, a link to the recording of this press conference. And I will be sending out the press release relatively soon here, within the next 15 minutes or so. Thank you again. Don't hesitate to reach out if we can be helpful with anything else. And thank you for joining us today.